As Chicago's restaurants go under tighter COVID restrictions today, pushback is growing across the city and suburbs.
An attorney in Crystal Lake filed a lawsuit yesterday on behalf of 37 restaurants, arguing the governor's emergency powers to issue such orders have run out. He also seeks an emergency restraining order to prevent the mitigation rules from going into effect tomorrow in the county. The petition will be heard in McHenry County Court at 10 o'clock this morning when a judge could issue a ruling.
Joining us now with more on these legal battles, Northwestern law professor Nadav Shoked. Good morning.
Good morning. How are you?
Doing well. Thank you for joining us this morning. So first and foremost, we're curious, how much power does the state have when it comes to local municipalities, local villages, local towns, in terms of what they do with their restaurants and bars?
Yeah, at the end of the day, in Illinois, as in basically all states in the U.S., the state has almost absolute control over what local governments do. So to the extent the state wants to preempt them and to force them to close restaurants, or on the other hand, to open them, it will be able to do so. The only question is there enough power in the governor, according to the current state laws, to do so?
Right, because many suburban mayors have announced that they are not enforcing these mitigations here. Orland Park, Libertyville, just to name a couple. So how do you see that playing out? Can state police just come in and shut everything down?
Well, the way it's going to play out is the way you predicted in your original reporting, in that they're going to try and sue the governor to claim that the governor doesn't have the power to close down the restaurants. And if they insist on themselves not closing them down, then the governor will sue them. And then it will be up to a court, starting with the lower courts, eventually theoretically going all the way up to our Supreme Court, to decide whether or not the governor, under the current emergency laws, actually has the power to shut them down. But otherwise, you are correct that theoretically, if a city refuses to shut down and the governor thinks he has the power, he can send the state police to shut it down. But we can then imagine them sending the local police to send the state troopers out. So it's highly unlikely to happen. It will all play out in court.
How about liquor licenses? Would the governor be able to say, okay, well, you're not going to shut down your restaurant, but I can pull your liquor license?
That'd be a bit more problematic, because in most of the state, liquor licenses are actually issued by the local government.
Okay.
So the local government that's empowered to give the license or to take it away.
Real quickly, want to get your thoughts on the other big battle happening in the state, the decision over fall sports. As you know, IHSA moving forward with fall sports, including basketball. So could there be a legal battle with that decision?
It's a bit even tougher to imagine that one, because it's tough to, school districts have even less powers in our state laws, and again in the laws of most American states, than local governments. They do not have, for example, home rule powers, and therefore it's kind of tough to see them arguing that they have some sort of protection from state powers, and therefore I think that their argument is going to be tougher. To an extent, they're going to eventually go to court, which they really haven't done so far. What they will probably try and argue is that under the current statutes, as adopted by the state legislature, the governor lacks the power to directly control school activities, but rather those powers are given on the local level to the school districts, and on the state level to relevant state bodies and to the state legislature, currently not to the governor.
All right, Northwestern law professor Nadav Shoked, we appreciate your time this morning.
Thank you.
Thank you.